Alright, 6050705, Decree of Dissolution. If in a test, testing. 6050705, Decree of Dissolution. If and after a hearing the court determines that one or more of the grounds of judicial dissolution described in 6050702 exist, and the court may enter the discovery of dissolving the limited liability company or specifying the effective date of dissolution, the clerk of the court shall deliver a certified copy of the decree to the department, which shall file the decree. After entering the decree of dissolution, the court shall direct the winding up of the liquidation of the limited liability company activities in accordance with the statute 605707009, 6050713, subject to objection. In the proceeding of judicial dissolution, the court may require all creditors, limited liability companies to file with the clerk of court the receiver in the form of the court may be prescribed in proofs that under oath of their respective claims. The court requires that the filing of the claims, the court shall fix a date which may not be earlier than 4 months after the date of the earth order as the result of the day of the filing claims. That prescribed the deadline of the filing claims shall be given to the creditor claimants before the date of the so fixed. The court may extend the filing date following the claims of the court or the creditor's claimants filings of the file. The proof of the claim before the date of the fix may be buried. The order of the participating in the distribution assets of the limited liability company section does not affect the enforceability of the record mortgage, lien, or perfected security interest of the rights of the person in possession of real personal property. Real or personal property. 6050706, election is the purchase instead of the dissolution and proceeding initiating the member of the limited liability company under section 6050702. 1B, dissolve the company may elect, or to elect one or more of the members may elect to purchase the entire interest of the petitioner in the company at the fair value of the interest in election pursuant to the section irrevocable unless the court and determines that the equitability is to set the modified election. An election is purchase pursuant to the section may be modified in the court within 90 days after the filing petition pertaining to the members of the section under 6050707. 02, 1B, 1, and 2 add to such a later time as the court may allow. If the election is purchased and filed with the company shall within 10 days, therefore, given the written notice to all the members that other than the petition member, the notice must describe the interests of the company owned by and each petition member that may be advised the recipient of the right to be joined the election to purchase the petition members' interest in accordance with the section. Members who participate must file the notice of the intention to join the purchase within 30 days of the effective date of the notice. A member who is filed with the election notice must the intent participation with the election purchases thereby becomes the party proceeding shall participate in the purchase of the portion of the ownership interest as of the date of the first election, which will be filed unless the members otherwise agree that the court otherwise directs. Any other election to purchase that has been filed with the limited liability company one or more members of the proceeding of 6050702 1B and 2 may be discontinued and settled, and the petition member may not sell or otherwise dispose of interest of the petitionary in the company unless other court determines that it would be equitable for the company and the members other than the petitioner to authorize discontinuance, settlement, sale, and other disposition or the sale of the pursuant deadlock sale provisions described in 6050702 1B. 3. If within 60 days after the filing of the first election, the parties reach an agreement so that the fair value of the terms of the purchase of the petitioner's interest, the court shall enter an order directing the purchase of petition interest on the terms of the condition agreed to be agreed by the parties, unless participation interest is required pursuant to deadlock sale provisions before the order. 4. If the parties are unable to reach an agreement as provided in the subsection 3 of the court, upon the application of the parties shall proceeding of determining the fair value of the petition interest as the day before the date of which the petition was filed, as other dates of this court deem appropriate under the circumstances. 5. Upon determination of the fair value petitioner interest of the company, unless the petitioner interest has been acquired pursuant to the deadlock sale provision before the order, the court shall be entered in order directing the purchase upon such a condition of the court deems, which may include the payment of the purchase, the price, and installments which necessary interest of the equity provision, the security of the insurement of the purchase price, and additional costs, fees, expenses that have been awarded. The interest to be purchased members, the allocation of the interest along among the members allocating the petition interest among the holders of different classes of series interest of the company in the company. The course shall be set shall attempt to preserve existing distribution voting rights among the holders in different class, insofar as practicable, may direct holders of specific class and classes series note not participating in the purchase. Interest may be allowed to raise from the date determined in the court of the equitable. However, there and other court finds the refusal petitioner member to accept the payment of the arbitrary, otherwise in good not in good faith, the payment of the interest is not allowed in the court's finding of the petition member the probable grounds and under statute 6050702 1B 3 and 4, and award of the petition member the reasonable fees at the expense of the counsel experts employed by the petitioner. 6. Upon the entry in order under the subsection 3 and 5, the court shall dismiss the petition, dissolve the limited liability company. Petition members shall no longer have the rights or status of the member of limited liability company, except for the right to receive the amounts awarded by the order of the courts, which shall be enforced in the same manner as the judgment. 7. The purchase ordered pursuant to subsection 5 must be made on the 10 days of the date of the order is final, unless before that date the limited liability company files a court notice of the intention to dissolve 6050712. In this cases of article dissolution, the company may be filed within 50 days after upon the filing of articles. The limited liability company shall wound in accordance with the statutes 605079. 0709 and 0713. The order entered in pursuant to section 5 should no longer be enforced except for the court may be awarded the petition member reasonable fees except and expense counsel experts in court subsection 5. The petitioner may continue to pursue any claims previously asserted on the behalf of the limited liability company. Payment of the limited liability company pursuant to any under the subsection 3, subsection 5, other than the award fees expenses pursuant to section 5 is the subject of 6050405. 6050707, Articles of Dissolution, filing of Articles of Dissolution. Upon the occurrence of the event described in 6050701, limited liability company shall deliver the filing articles as provided in the section. Articles of Dissolution must be stated the following: the name of the limited liability company delayed. Effective date of the limited liability company dissolution, and the dissolution is not to be effective at the date of articles in the dissolution that are filed in the department. The occurrence with the result of the limited liability company's dissolution. If there are no members with no members with no name, if there are no members, the name, address, and signature of the person appointed with accordance with the subsection to wind up the company, the articles of dissolution of limited liability company shall be delivered in the department. The department finding the articles conforming to the law issue when and all fees have been prescribed in the chapter files the articles of dissolution, issues the certificate of dissolution. 4. If upon the filing articles of dissolution, limited liability company shall cease to conduct business, shall continue solely for the purpose of winding up its affairs in accordance with 6050709, experts for the purpose of the lawsuits, other proceeding appropriate actions provided in the chapter. 6050708, revocation of our dissolution. A limited liability company has dissolved the result event described in 6050701 and 1 through 3 and filled articles of dissolution with the department, but has been filed in the statement of termination that because of the effective may revoke the dissolution at any time before 120 days after the effective date of the articles of dissolution. 2. The revocation or the dissolution shall be authorized in the same manner as dissolution was authorized. The revocation of the dissolution authorized the limited liability company shall deliver the state of the revocation dissolution to the department of the filing together with a copy of the articles dissolution, which must include the name of the limited liability company, the effective dissolution which was revoked, the date of the statement of revocation dissolution authorized, the substantial compliance with the subsection 3, the revocation of dissolution effective with the department of the files of the statement of revocation dissolution. 5. When the revocation of dissolution becomes effective, the A company requires the company carrying activities affairs of dissolution and have never occurred. Subject to the paragraph C, the liability incurred with the company's dissolution before the revocation is determined. If the dissolution has occurred, the rights of the third party assigned third party is arising out of the conduct of the reliance of the dissolution before the third party knew and had notice of revocation, but may not be adversely affected. 6050709, winding up. A dissolved limited liability company shall be winded up at activities and affairs except for the otherwise provided in 6050708, 6050715. That companies continue after dissolution only for the purpose of winding up the winding up activities, affairs, and limited liability company. 2A shall be discouraged, make provision of the company debts, obligation, and other liabilities as provided in the 6050710, 6050713. through 605-0710 through 605-017. Settle in the company activities and affairs of the marshal, distribute the assets of the company. May 1. Preserve company activities, affairs, property, and going course concern of the responsible time. 2. Prosecute defending actions proceeding with other civil, criminal, or administrative. Transfer the title of the company to real estate to other properties. Settle disputes, survive mediation, or arbitration. 5. Dispose of the properties that will be distributed in kind to members. 6. Perform any acts necessary, appropriating, and winding up. 3 is dissolve limited liability company has no members. The legal representative of the last person to be having member may wind up with the activities affairs of the company. The legal representative does so. The person has the power of the sole manager under 605-04-073 to demand the manager to the purpose of 605-03-041. If the legal representative under Section 3 declines and fails to wind up the company activities affairs of the person appointed with to do so, to consent of the transfer, owning the majority of the right to receive, distributing, transfer at the time the consent effect of the person appointed with the subsection powers of the sole manager under Statute 605-04-07 is deemed the manager for the purpose of Statute 605-07-03-04. 5. Any circuit court may be ordered to the judicial proceeding of the winding up of the dissolved limited liability company, including the appointing of one or more persons to wind up the company activities and affairs. 1. Application member of the manager if the applicant established good cause on the application of the transfer. The company does not have the members. 2. The legal representative of the last person to have been a member declines and winds up the company's activities and affairs. 3. Within a reasonable time following the dissolution of the person has not been appointed pursuant to subsection 3 on an application of the creditor of the company if applicant establishes good cause, but not only if the receiver, custodian, or other person has not already been appointed for the purpose under this chapter. In connection with the proceedings under 605-0702, if the receiver, custodian, and other purpose has already been appointed for the purpose of 605-0704, the persons and persons appointed by the court under subsection 5 may also be designated trustees of the receiver of the company and the authority to take charge of the limited liability company's property, to collect debts and property belonging to the limited liability company, to prosecute and defend the name of the limited liability company. Otherwise, all subjects also may be necessary to the purpose proposed, discussed, described, and appoint the agent or the agents under them. To do all that might be done by the limited liability company if and being with the necessary final statement on unfinished activities and affairs with the limited liability, the powers of the trustee receivers may be continued as long as the court demands and necessary is above the purpose. 7. If the dissolved limited liability company has completed winding up the delivery at Department of the filing and the statement of determination that provides the following: the name of the limited liability company, the date of the filing or initial articles of organization, the date of the filing, the initial articles of dissolution. The limited liability company has completed the winding up of the activities and affairs and is determined will file the state determination. Either other information of the determined authorized representatives, the managers, and the office of time of dissolution, survivor, manager, and managers, and if no members shall thereby trust the members, the creditors dissolve the unlimited liability company. Trusters may distribute the property and limited liability company discovered in dissolution, conveying the real estate and other properties to take such action other than necessary on behalf of the name of the dissolved limited liability company. 605-0710, disposition asset windups and winding up the activities such as affairs limited liability companies must supply the assets and discharge the obligation of the creditors, including the members who credit. 2. After limited liability complies with the subsection 1 of the surplus must be distributed in the following order, subject to charging the order in effect of statute 605-0503. To each person owning the transferable interest of the reflecting contributions may not be previously entered among the equal value of the return contributions. To the member of the person associated with the in the proper portions of share distribution before the dissolution, except for the necessary to comply with the transfer effective under 605-0502. If the limited liability company does not have a sufficient surplus to comply with the paragraph 2 and 2A, any purpose is distributed among the owner's transferable interest portion to the value of the respective unreturned contributions. All distributions under section 2 and 3 must be paid in money. 605-071 1 0605-0711 known claims dissolve limited liability. 1. Dissolve limited liability companies, successors, and entities defined in subsection 14 may be disposed of knowledge against the following procedures described in subsection 2 through 7. Dissolve limited liability successors entity shall have to deliver to each of the known claimants written notice of dissolution after the effective date. The written notice must be on the following, provided the reasonable description of the claim. The claimant may be entitled to assert. B. The state whether the claimant is admitted and not admitted in whole or in part, or the if admitted, 1. The amount of admitted, which may be given the date, and the interest obligation is fixed by an instrument of the indebtedness. C. The provided mailing address with the claim to be sent. D. The state and the deadline, which may not be less than 128 days effective of the written notice confirmation of the claims must be delivered with dissolved limited liability companies, successor entities. The state that dissolved limited liability successor entities made a distribution other claimants and members transferee limited liability company persons interest without further notice. So the dissolved limited liability company successors entity may be rejected in whole and in part. Claim may be claiming it pursuant to the subsection mail notice for the rejection, claiming it with 98 days after the receipt of the claim and in all relevance, and at least 150 days before the expiration of 3 years, the period of the effective date of the dissolution. Notice of the dissolved limited liability successors entities subsection may be accompanied with the company of the section. 4. Dissolve limited liability company successor in electing the following the procedures described in subsection 2 and 3, and those shall be given the notice of the dissolution of limited liability to ensure the known claims the contingent upon the occurrence and non-occurrence of the future event and otherwise conditional unmatured request of the person presenting to the claims in accordance with the terms of the notice. The notice must be substantially the same forth in the same manner as described in subsection 2. 5. The dissolved limited liability company successor entity other than claimant whose knows the name the contingent conditional and unmatured and the security limited liability company and it determines the sufficient provided with the compensation to claim it, and if the claim matures, the dissolved limited liability company successor entity shall deliver such other claimant within 90 days after the receipt of the claim, and in all events after at least 150 days before the expiration of the 3 years after each effective date of dissolution. If the claimant is offered the security does not deliver the writing and the dissolved limited liability company successor entity the notice of rejection, and the officer offer it within 120 days after the receipt of the security, the claimant deemed the accepted such security as the source to satisfy his or her claim is against its limited liability company. 6. A dissolved limited liability successor entity that gives the notice in accordance with subsection 2 and 4 shall petition the circuit court to the applicable county to determine the amount of the form of the security that's sufficient to provide the compensation to the claimant that it was rejected other than the security made by the present subsection. 7. A dissolved limited liability company successor entity that gives notice of the accordance with subsection 2 the petition of the circuit court is applicable to the county to determine the amount of the form of the security that will be sufficient to provide compensation of the claimants with the claims known as the limited liability company successor entity with the identities unknown. The court shall be appointed with the guardian ad items and present all claims with identities are unknown in the proceeding of them brought through under the subsection. Reasonable fees and the expense of the guardian, including the responsible expert witness fees, shall be paid in the petitioner proceeding. 80. The given notice of the maybe other purpose of the section does not revive the claim that barred, extended otherwise the applicable statute limitations constituting an acknowledgement dissolved limitation liability company. The successor entity of the person whose such notice is sent to the proper claimant does not operate the waiver in defense of the counterclaim in the respect of a claim asserted by the person to which such notice is sent. 9. Dissolved limited liability company successor entity. The following procedures described in subsection 2 through 7 apply. Pay all the claims that demanded with made an adjunction in accordance with subsection 3. Post the security offered no rejected pursuant subsection 5. Post the security offered security proceeding under subsection 6 and 7. Pay and make provisions other than known obligation to limited liability company or the successor entity. If there are sufficient funds such as the obligation must be paid in this provision, the payment that may be made in sufficient funds of the claim obligations paid with the provided according with the priority among the claim the equal priority retailable Tably extending for the funds of the legal available remaining funds that should be distributed to members of the transfer of the dissolved limited liability company. However, the distribution may not be made with the expiration of 150 days after the notice of the rejection given to the pursuant subsection 3 in the absence of this actual fraud judgment of the managers of the dissolved manager limited liability company, members of the dissolved member of the managed limited company, other person winding up the limited liability company governing the purchase, successor entities, the provision made in the payment of the obligation to under the paragraph of the 6 as discovered. Paragraph D is inconclusive. 10. A limited liability company's successor entity filed with the procedures in subsection 2 and 3 shall pay the reasonable provision to pay all known claimed obligations, including contingent, conditional, unmatured claims known as dissolved limited liability company or the successor entity, all claims of the known to the dissolved limited company or the successor entity, but the identity of the claimant is unknown. If there is sufficient funds, the claim must be paid, and the provision made with the payment must be made. If there are insufficient funds, the claims of the obligation should be paid, with providing accordance with the priority among the claims of the equal priority, the retaliable with the extended funds with legal availability. Remaining funds should be distributed to the members transferred to the dissolved limited liability company. 11. A member transferred to the dissolved limited liability company to which each assets were distributed pursuant to the subsection 9 and subsection 10 is not liable to claim against the limited liability company in an amount of excess members of the excess member transfer pro rata share of the claim, the amount of distributed by the member of transfer, whichever is less. 12. The member transfer of the deserved limited liability company did with assets distributed by the pursuant to the subsection 9 if it is not liable to claim against the limited liability company, which the claim is not limited liability successor entity of which the proceeding is not begun at before the expiration of 3 years after the effective dissolution. 13. The aggregated liability of the person of the claim against the dissolved limited liability company arising from the subsection 605.0710 may not exceed the amount distributed in the person dissolution. 14. As under the section 605.0712, the term successor entity includes the trust, receivership, or other legal entity and governed by the law of this state, which will remain assessed liabilities. Dissolved limited liability company is transferred, which exists solely for the purpose of prosecuting, defending, and suits against the dissolved limited liability company, thereby enabling the dissolved limited liability company to settle, close, and activities affairs of the dissolved limited liability company, to dispose and convey the property of the dissolved limited liability company. The discharge of limited liability company, dissolved limited liability company is distributed to dissolved limited liability company members and transferees as remaining assets, but not purposes continuing the activities and affairs for which dissolved limited liability was organized. 15. As used in Section 60 and Section State Statute 605.0712 and 605.0713 is applicable county means the county in which the state which the liability company principal pays is located with the located effective date of dissolution. If the company is effective date of the dissolution, the no principal office, then the company and the company has at the effective dissolution had an office in the state. If no, the state, then the county and the company registered office was located. 16. Is used in section their term to no claim. The claim that includes the unliquidated claims does not include the contingent liability that has been not matured and the immediate rights to bring suit and claim based on the event occurring with the effective dissolution. 605.0712. The other claims in the dissolved limited liability company, the successor entities is defined in 607.0711 may chose to execute the following procedure to resolve the payment unknown claims. The company and successor entity may file notice of dissolution to the department of the form described in the department request of the person who has the claims against the company, which are now the company and successor entity presents in accordance with the notice. The notice must state the name of the company, date of the dissolution, describe the information must include, but the claim state of the claim must be in the writing of the writing a mail address to which the claim may be sent. 3. The state of the claim against the claim company is barred unless the action be enforced of the claim and commenced within 4 years after the filing notice. B. The company successor enters may publish a notice of the dissolution requires the person who is claimed against the company to present in accordance with the notice. The notice must 1. Be published in the newspaper, general circulation in the county which is dissolved limited liability company principal officer is located in the principal office, notice and located in the company, located in the state of the county which the office of the company registered agent is located. 2. Describe the information that must be included in the state of the claim that must be written, provided the mailing address and the claim to be sent. 3. State the claim against the company is barred unless the action is to enforce the claim is commenced within 4 years after the publication of the notice. 2. If dissolved, limited liability company complies with paragraph 1A and 1B, unless sooner the barred and other statute limited action claiming the action following claimant is barred unless the claimant commences an action and enforce the claim against the dissolved limited liability within 4 years after the publication of the notice. A claimant will did not receive the notice of the record under 6050711. The claimant which claimed timely dissolved limited liability company may act upon. C. A claimant whose claim is contingent based on an event occurring the effective date of dissolution. 3. A claimant that is not barred of section and other statute limitation actions may be enforced against dissolved limited liability companies to the extent the undistributed assets be the except the otherwise provided 6050713 assets limited liability company have been distributed as dissolution against the member of the transfer for the extent of the person proportionate share of the claim the company's assets distributed by the member of the transferee after the distribution whichever is less the person total liability for all the claims under the subsection may not extend the total amount of the assets distributed to the person of dissolution. 6050713 court proceedings dissolved limited liability company have been published under the notice 6050712 1A and 1B. They may file an application with the circuit court in the applicable county to define 6050711. Determination of the amount of the security is provided with the payment claims and the contingent that have not been made known by the company and based on the event of the occurring the effective date of the dissolution, but which based on the fact of knowing the dissolved company reasonable expected as arise on the effective date of the dissolution security is not required of the claim and the other reasonable anticipated to be barred on 6050712 within 10 days of the filing application under section 1 of the dissolved limited liability which must give notice to provide preceding each claimant holding the contingent claim known to the company. In proceeding under the section, the court may appoint the guardian in the items represent all the claimants, identify the unknown responsible fees for the expension of the guardian item, and including all responsible expert fees must be paid to the dissolved limited liability company. A dissolved limited liability company provides security amount of the item in the court ordered, and the courts under subsection. And 1 satisfies the company obligation with respect to the claims the contingent have not been made in the company and or are based on an event of occurring after the effective dissolution. Such claims may not be enforced against the members or transferees that receive liquidation. 6050714 Administrative Dissolution. The Department of Dissolved Limited Liability Company administrates the company does not deliver an annual report to the department at 5 p.m. the Eastern Time on the third day of the Friday of each September of each year. Pay a fee or penalty due to the department under this chapter appointed to maintain the registered agent as required in 6050113. Delivered of the final statement changing the 6050114 within 30 days after the change has occurred with the name and address of the agent unless the 30 days after the change has occurred the agent had filed the statement of the change under 6050116 the change was described the change was accordance with 6050114 for the administrative dissolution of limited liability company failure to annual report must occur within fourth Friday of the September of each year. The department shall issue the notice and record administrative dissolution of limited liability company dissolved the future failure to file annual report issuance notice of the electronic transmission and limited liability company that has provided the department with an email address. If the department determines that one or more of the grounds exist of the administrative dissolving limited liability company under the paragraph 1B, 1C, and 1D, the department shall notice in record the unlimited company in the instance of the administrative dissolved and limited liability company issuance of the notice for the electronic transmission to the limited liability company provided the department the email address. If then within 60 days sending the notice of the administrative of the pursuant subsection limited liability company does not correct each ground of the dissolution in paragraph 1B, 1C, 1D, and demonstrate the reasonable satisfaction department of the grounds determined the department does not exist. The department dissolve limited liability company administrative issue the company the notice of the record of the administrative dissolution states grounds dissolution issuance of the notice of administrative dissolution may be electronic transmission by the limited liability company that provided the department with an email address. 5. A limited liability company that has been administratively dissolved continued existence but not only carry out the activities of limited activities and affairs liquidated distributes and its assets notify claims under the statute 6050711 and 0712. Administrative dissolution limited liability company does not terminate the authority or registered agents of the for service or process. 6050715 reinstatement limited liability that is administrative dissolved 067 6050714 former statute 608 may apply to the department reinstatement anytime the effective date of the dissolution of the company may submit all fees, penalties, and owned company the rates provided the law time the company applies with the reinstatement together with the application reinstatement prescribed furnished to the department which signed the registered agents authorized representing the company in the state the limited liability company the street of the company principal office the mailing the date of the company address organization of the company federal and employer identification number if the number whether one has implied the name of the title capacity address for at least one person the authority to manage the company additional if necessary appropriate and enable the department to carry out the chapter 2 in lieu of the requirement of filing the application and reinstatement is described in the subsection if the administration of dissolved limited liability company may be submit all fees and penalties to company rates provided by the law at the time of the employee's reinstatement together with the current annual report signed with the registered agent authorized representative of the company contains the information described in subsection 1 if the department determines application reinstatement contains the information required in subsection 1 and subsection 2 the information is correct upon payment of the also required fees and penalties the department shall reinstate the limited liability company for the reinstatement under this section is effective A if the reinstatement relates back to takes effect of the effective date of the administrative dissolution. The limited liability company may resume its activities affairs of the administrative dissolution as it not occurred the right of the person is in of an act of mission reliance of dissolution of the person knew that notice of the reinstatement is effective. 5. The name of the dissolved limited liability company is available with the assumption of use of another business entity until 1 year after the effective dissolution under the dissolved limited liability company the department of the record executed the required pursuant in the section statute 6050203 permitting immediate assumption of the use of the name of the other limited liability companies. 6050716 judicial review of the denial of reinstatement. The department denies the limited liability application reinstatement after the administrative dissolution. The department shall serve the company with a notice of record explaining the reason of the denial. Within 30 days after the service of denial reinstatement, the limited liability may appeal the denial by petitioning the circuit court. In the applicable county is defined in statute 605071115 to set aside a dissolution. The petition must be served in the department of containing the copy of the department notice of administrative dissolution of the company application of the reinstatement of the department of notice and denial. The court may order the reinstatement dissolved in limited liability company to act on other court order in some appropriate. 605-017 effective dissolution. Dissolution of limited liability company does not transfer the limited liability company assets, prevents commencement of the proceeding against the limited liability company in its name, abate the suspending of proceeding and pending against the limited liability company the effective date of dissolution. D. Terminate the authority registered agent of limited liability company. 2. Expectly is provided in statute 605-0715. 5. The name of the dissolved limited liability company is not available for the assumption of any other business entity under 120 days after the effective date of the dissolution following the state of determination of as earlier. 605-0801 direct action by a member subsection is a member maintaining direct action against another member of the member limited liability company to enforce members' rights and otherwise protect members' interests including rights, interests, and other operating arrangements to chapter arising independently of the membership relationship. A membership maintaining a direct action under this section must plead to provide actual threatened injury, not solely result of the injury suffered, threatened, or suffered by a limited liability company. 605-0802 derivative. The member may attain a derivative action to enforce the right of the limited liability company. The member first makes the demand on the other member. The member managed limited liability company. The manager managed limited liability company, requesting the manager or other managers of the cause of the company to suitable action to enforce the right of the managers or other members to do not take action with responsible time do not exceed 90 days. A demanded under section with futile irreparability injury would result in company waiting other members as managers taking action to enforce the right in accordance section. 605-0803 proper plaintiff. The derivative action to enforce right of the limited liability company may be maintained only by a person who is a member at the time action and commencement and 1. was a member in conducting giving rising to the action occurred. 2. was a status of member devoted to the person operating in law pursuant to the terms of operating arrangement which member the terms of conduct. 6050804 Special Litigation Committee. A limited liability company named and made it the part of the derivative action company is appointed the Special Litigation Committee to investigate the claims asserted by the derivative determination whether pursuant to the actions for the best interest of the company. If the company appoints a special litigation company that, on motion, except for the good cause shown in the cause of the say as derivative acts of time responsible and necessary to permit the committee to make an investigation, subsection does not prevent the court from the enforcing the person's rights under the circumstances operating in this chapter, including the person's information in statute 6050410, or exercising equitable other powers, including granting extraordinary relief in the form of the temporary restraint of the other order, primarily injunction. A special litigation committee must be composed of one or more disinterested independent individuals who may be members. The special litigation committee may be appointed a member of the managed limited liability company. The contents of the members are not maintained to the party of the derivative action when otherwise disinterested, independent, and hold a majority current percentage of other interests or profits of the company owned by all members of the company who may be named as parties of derivative action, otherwise disinterested, independent. B. In managers managed limited liability company, major managers are not named as parties of derivative actions who otherwise disinterested or independent. C. Upon limited liability company consisting of a panel or one or more disinterested independent persons. 4. After an appropriate investigation, special litigation, the committee shall determine which action is the best interest of limited liability, including conducting, dismissing, and settling derivative action and taking another action that the special litigation committee deems appropriate. 5. After making the determination under subsection 4A, the Special Litigation Committee shall file the cause to file with the court statement of the determination and reports supporting the determination shall serve each part of the derivative action with a copy of the determination and report upon the motion of the enforcement determination. Special Litigation Committee. The court shall determine whether the members of the court were disinterested and independently in reasonable care with the committee having a burden of proof. If the court finds that the member of the committee was disinterested, independent, that the committee acted in good faith, independently, with a reasonable care, the car may enforce the determination of the committee. Otherwise, the court may dissolve the derivative action entered under subsection 1, allow the derivative action to continue under the control of the plaintiff. 6050805 Power expenses. Proceeds and expensive. Expect otherwise subsection 2, the proceeds and benefits of derivative action are 6050802, when the judgment, compromise, settlement belonging to the limited liability company, not in the plaintiff, but the plaintiff receives and any proceeds the plaintiff shall remit immediately to the company. If the derivative action success, a whole part of the court, the reward of the plaintiff reasonable expense, including the reasonable attorney fees and the cost of the recovery of limited liability. 6050806 Voluntary Dismissal Settlement Notice. Derivative on once the behalf of the limited liability company may be voluntarily dismissed on settled with the court's approval. If the court determines the proper voluntary dismissal settlement and a substantial effect of the interest of liability company members of the class series, the voting group of the members of the court shall be directed notice given to the members affected. The court may be determined the majority of which derivative action shall be the expense of the given notice. 6050901 Governing Law. The law of the state of the jurisdiction of the foreign limited liability company, the organization, and internal affairs of the foreign limited liability company, and the liability of the member as member and manager as manager for the debts or obligations or other liabilities of foreign limited liability companies. 2. Foreign limited liability company may not be derived certificate as authority. Reason for the difference between the jurisdiction and the formation of the state. The certificate authority does not authorize foreign limited liability company to engage in any business, exercise, or any power the limited liability company may not engage in exercise in the state. 6050902 Application for a certificate of authority. A foreign liability may not transact business in state and obtain a certificate of authority for the Department of Foreign Liability Company may apply for the certificate of authority to transact the business in the state, delivering an application to the Department of the filing. Such application must be made in the prescribed in the Department. The application must continue the following: the name of the foreign limited liability company, if the name does not comply with 6050112, alternate name adopted by 6050906, the name of the foreign limited liability company jurisdiction formulation. The principal office mailing address of the foreign limited liability company, the name of the street, and the address of the state of the written acceptance of the foreign limited liability company initial registered agents, the name of the title, the capacity address of at least one person that has the authority to manage the foreign limited liability company, and additional information necessary to appropriate in order to enable the department to determine whether the foreign limited liability company is entitled to the application of the certificate of authority to transact its business in the state, determine to assess the fees and the prescribed in this chapter. A foreign limited liability company shall deliver the completed application in subsection 1 of the ICOM certification of existence record and similar important signed to the Secretary of State and other official custody of foreign limited liability company publicity on file records on jurisdiction formation dated not more than 90 days of the delivery of the application of the department. 3 to 4, the purpose of complying with the requirements of such chapter description, the department may require each individual sell or foreign sales limited liability company transact business in the state of the separate the application the certificate of authority to make the other filings as may be required purpose complying with the requirements of the chapter if in each of the series or sell was separately foreign limited liability company. 605-0903, effective the certificate of authority. Unless the department determines the application of the certificate of authority, foreign limited liability company can transact business in the state does not comply with the filing requirements of this chapter. The determined shall be upon the payment of the filing fees authorized foreign limited liability company to transact the business and the application of the certificate of authority. The filing department of the application of the certificate of authority authorizes the foreign limited liability company that files application to transact business in the state, subject, however, the right to the department is suspended and revoke the certificate of authority is provided in this chapter. 605-0904, effective failure to the certificate of authority. Foreign limited company attracting business and in the state of the successor may not maintain the action proceeding of the state unless the certificate of authority to transact the business in the state. The successor of the foreign limited liability company in the transacted business in the state without certificate of authority assigns the cause of the action arising out of the business maintainable proceeding based on the cause of the action cohort of the state until the foreign limited liability company's successor obtains the certificate of authority. 3. The court may not proceed the foreign limited liability company is successor and assigning determines whether the foreign limited company is successor requires the certificate of authority if determines the court may further state the proceeding of the foreign limited liability company's successor obtains the certificate. The failure of foreign limited liability company to have the certain certificate of authority to transact the business state does not impair the validity of the contract to act of the foreign limited liability company to prevent the foreign limited liability company defending the action and proceeding in the state. A member of the management of the foreign limited liability is not liable to debts, obligations, other liabilities. Foreign limited liabilities company solely based on foreign limited liabilities company transaction business in the state of certificate of authority. 6. If the foreign limited liability company transacts business in the state with the certificate of authority, cancels the certificate of authority. Its appointment as department of the agent certifies agent services the process of rights of acting as arising in the transaction business in the state. 7. A foreign limited liability company transacts business in the state obtaining the certificate of authority is liable for the years and parts of during the transacted business that the state obtaining a certificate of authority is amount equal to all fees penalties which imposed in the chapter upon the foreign limited liability company had duly applied and received certificate as transacting business as state is required under the chapter. In addition, payments prescribed by foreign limited liability companies are a civil penalty is at least $500 but no more than $1,000 for each year or part therefore during which each transaction business without certificate of authority. The department may collect all penalties and due under subsection. 605-0905, activities that not constitute transaction business. The following activities, among others, do not constitute transaction business with the meaning of 605-0902. Maintaining, defending, and settling any proceedings, holding a meeting and managers and members, and carrying out the other activities concerning internal company affairs. Maintaining bank accounts, maintaining manager, agencies, transfer, exchanges, registration, foreign liability companies owning securities, maintaining trustees depository with respect to those securities. E. The settling of the independent contractor's solicitation, obtaining orders whether to mail or other employees, agencies, or otherwise orders that require acceptance outside of the state become contracts. G. Creating, acquiring indebtedness, mortgages, securities, interests in real or personal property, securing and collecting debts securing and collecting debts, enforcing mortgages, security, interest of the property, securing the debts. Transaction business, interstate commission, conducting an isolated transaction completed within 30 days that is not one of the course of repeated transaction-like nature. Owning and controlling a subsidiary corporation incorporated with the limited liability company for the transaction business with the state, voting for the stock of each subsidiary corporation, voting of the membership interest of each of any limited companies as it's lawfully acquired. Owning a limited partner interest, limited partner transaction business state unless the limited partner manages, controls, partnerships, exercises powers of duty general partner. 2M, owning without more or real personal property. The listing activity subsection is not exhaustive list of activities that do not constitute transaction business with a meaning. The owners of the state income of the producing real property, tangible personal property, other property excluded out of subsection constitute transaction business in the state of the purpose 6050902. The subsection does not apply to determining the contacts and activities of the subject, foreign limited liability companies in the service process, taxation, regulation under the law of the state, other corporations. 6050906, non-complying with the foreign limited liability company. A foreign limited liability company whose name is unavailable under what does not otherwise comply with the 6050112 may alternate name to comply with 6051012 the transaction business in the state. Alternate name adapted for the use of the state is in cross-reference the actual name of the foreign limited liability company of the records department. The actual name of the foreign liability companies subsequently because they are available in the state and foreign limited liability company chosen to change the alternate names of the company of the record, proving the change of the remembers the managers or other person having authority to execute the required pursuant to 6050203 shall be delivered in the Department of the Filing. The foreign limited liability company adopts the alternate name under the Section 1 and obtains the certificate of authority, which alternate name needs not to comply with the statutes 86509. After obtaining a certificate of authority, alternate name, foreign limited liability company transaction state, and under the alternate name unless the company is authorized the 86509 transaction business and state under another name. The foreign limited liability company unauthorized to transact business state changes its name and state changes name to one of the does not comply with the state statute 6050112 may not therefore transact business in the state until it complies with subsection 1 obtains amendment as certificate of authority. 6050907 Amendment of the Certificate of Authority. Foreign limited liability companies authorized the transaction business state and deliver the following amendment of the Certificate of Authority to reflect the change of the following. It's the name of the record, orders of the department in jurisdiction of the formation, the name of the state address of the state of the company registered agent and the state, unless the change is timely made in accordance with 6050114, 6050116. Any person identified in accordance with 6050902 and change of the title, capacity, address of the person, the amendment must be filed within 30 days in accordance with the changing described in the subsection must be signed and authorized representative for foreign limited liability company must state the following. A, with the name of the foreign liability company as it appears on the record of the department in jurisdiction of the formation. C, the date of the foreign liability company authorized to transact business in the state. The name of the foreign liability company that has been changed to the name of the relinquished or in its new name. The amendment of the change of the jurisdiction formation foreign limited liability company and statement of the change subject to subsection 4. The foreign limited liability company authorized to the business and state may be application of the department to obtain the amendment certificate to add a removal, change of the name, the title, capacity, address of the person with authority to manage the foreign limited liability company. Required the 6050902 the obtaining the original certificate of authority applied with the obtaining amendment certificate under the section and class unless Secretary of State official having custodian foreign limited liability companies publicize the filing records of jurisdiction formation does not require amendment to effectuate the change of the records. All right, cut.